Okay, I got these. I'm working on these. Got some files here. Gathered up all these lien assessments and lien assessment evidence. But I found this. I just wanted to read it to you. Here's a communication, uh, and it says, "Good morning, Natalie. Gail reviewed your question and advises as follows. The expiration of the CC&Rs without renewal is devastating to the association. In essence, the CC&Rs are no longer in effect. This means that they are not a lien on the properties. The power to collect assessment is extinguished, and the underlying corporation is the Wilcox Ranch Property Owner Association is no longer a valid association pursuant to Nevada law. In order to record new CC&Rs, you will need 100% approval of the members. Of course, that is not likely since there are a number of members who do not even pay assessments any longer. However, it is Gail's opinion you may be able to seek declaratory relief from the court to impose new CC&Rs in order to enforce assessments and maintain the common area. This would require filing a lawsuit with the members of the community that are in support of reinstating the CC&Rs as the plaintiffs. You may wish to speak with your neighbor to determine how to proceed. Meanwhile, we cannot move forward with collections because without the CC&Rs, you have no ability to enforce the assessments. I'm sorry for the bad news. Please let us know if you wish to move forward with any of the members of the community." There's a whole bunch of other stuff in here.
Wow.
Well, the thing is, I just found that today's date is December 7th, 2025. I found this in the records that I hadn't looked at all of them.
She's putting legal documents on our titles that say you are subject to Wilcox Ranch liens and a collection policy.
In 6/22/16, document 4602183, recorded at the county.
So this is after that letter.
But it says in here, road assessments are levied pursuant to Article 3F of the Articles of the Corporation. So this is recorded by the attorneys and on 6/22/16. And then they went back and they recorded it again, the attorneys, re-record document 4789730 on 2/21/18. So they knew this is fraudulent concealment and this is fraudulent representation.
So they knew.
They never told us about this.
They did it twice.
Yeah, but if I got a stack here, this would take me hours. Look at this. It's all... here's the one on Millennium Property. They were assessing properties, and I'm going to have to look at all the dates. This is in 14, but they're all here. They were liening properties, the attorney. And I know you got some threat letters. I got documents in here, the representation of the title companies about the payments, $100 here, $125 here.
The authority of the association. And what I agreed to.
Yeah, this is the effective title, like I was saying, and they purposely concealed this from us. I didn't know about all this stuff. They didn't tell any of the members. Did they tell you that when your court proceeding against them?
No. You mean the two court proceedings?
Yeah.
The two court proceedings, and there's
another. Let me read another one. You must have CC&Rs to be a common interest community. I have ordered a copy from the title company. The CC&Rs are what creates the lien for assessment. You are also required by Nevada law to have a collection policy that you can send to the members each year when you adopt the budget. We can draft one for 1 hour of time for $275. Please let me know if the board wishes us to do so. I will provide the CC&Rs when I receive them. They are a controlling document of your association. Please let me know if the board determined to have a meeting and conference call with Gail in order to understand the common interests and obligations. Well, that's a problem. If I'd have known that, we wouldn't have bought the property if we didn't have the road maintenance. Now that, they don't want to pay. But this is a fraudulent concealment. They did not disclose this to us. And I'm saying the date. This letter was written February 5th, 2016. And there's a communications here and 2 responses. Let's see here. They knew about this February 11th, 2016, and then they went after, right after that. Let's see, right after, well, not right after, in 2016, the attorneys went and recorded it on our titles, and they were enforcing all this. I got a late fee, and I got a stack of people that have been damaged. They did not tell them about this, and they concealed it, and they went and gave us that letter at the meeting in 2022, but they didn't provide anything from their attorneys, nor did the other attorneys when we went to court. They knew this. We subpoenaed Gail Kern.
So let me get this straight. Any liens that were, or properties that were foreclosed on since 2001, that's not valid? How are they gonna? I think my property was one of the properties that was fraudulently liened and sold.
Well, there's a letter in there to Simone from attorneys talking about it in 2005.
That's who I bought my property off of.
Well, but there's all kinds of representations in these communications that I have in the files. They didn't tell us this. They didn't tell us this at the annual meetings. We got our property in 2017. I didn't know about this stuff. I didn't get copies of the declaration, and they knew about it, and they recorded it, and then they kept it going off and taking properties and quieting title like they had the authority to enforce all this and collecting the money. You know what? Stand by. I'm going to have to spend some time going through all these papers here and the collection of the money and all the representations by the titles, the title companies, and what I'm telling you, this is fraudulent concealment. Stand by.